case briefs, and so much more. LSData's got what you're looking for.
In the 1978 case of the Department of Revenue versus Asin of Washington's Stevedoring companies, the Supreme Court of the United States examined whether a state tax on a business involved in interstate commerce could be fairly apportioned and not unduly burden interstate commerce. The Constitution prohibits taxes on imports or exports, but allows taxes on businesses involved in those activities if the tax is fairly related to the services provided by the state. The case was prompted by the state of Washington's attempt to apply a tax on stevedoring, or the business of loading and unloading cargo from ships. In 1937, the state's initial attempt to implement this tax was declared unconstitutional under the Commerce Clause of the Constitution. Subsequently, in 1974, the state adopted a revised rule imposing a 1% business and occupation tax on services, which included stevedoring. The Association of Washington Stevedoring Companies and the Washington Public Ports Association challenged the constitutionality of the tax under both the Commerce Clause and the Import-Export Clause. The Supreme Court ultimately upheld the constitutionality of the tax, focusing on the nature of the tax, its impact on interstate commerce, and the state's interests in imposing the tax. In the court's decision, it reversed the Supreme Court of Washington's judgment and remanded the case for further proceedings. The court's ruling clarified the policies of the Import-Export Clause and concluded that the tax on stevedoring services provided within the state of Washington to imports, exports, and other goods did not violate the clause. This decision rejected past cases and distinguished between cases involving movement and non-movement of goods in interstate commerce.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.